judge ever has to do is sentence anyone. It's something that is part of the job. You all need to fully understand. I take an oath. My oath is to uphold the law, to apply the law. What we're dealing with is the legislature has dictated a lot of what judges can and cannot do. You need to fully appreciate that. The legislature has dictated what the laws of this state are. And as Mr. Amara pointed out, one of the laws is that the primary purpose of sentencing, written in the statutes, is to punish the offender. It is also written by the legislature, and this is something, again, in getting ready for all of this, I studied hard as far as what the law provides, and the law specifically says it's the intent of the legislature that offenders who actually possess, carry, display, use, threaten, or use, or attempt to use firearms should be punished to the fullest extent of the law. So those is the legal backdrop that I have to start with. I start with that, and then the legislature has, in a great many instances, eliminated discretion on the part of judges and taken upon themselves to almost dictate what we should and shouldn't do. They've created what is called the Criminal Punishment Code. That Criminal Punishment Score Sheet Code sets forth what the legislature would have a judge do in virtually every type of incident. It's a mathematical calculation which sounds cold and heartless, but that's what the legislature has put into place. A criminal punishment code score sheet, which mathematically sets forth the number of months somebody is supposed to spend in prison. We're dealing with the situation here that Mr. Dunn was charged under an indictment by the grand jury that convened with second-degree murder with a firearm. And that is a crime that, had he gone to trial and lost, is punishable by up to life in prison, carries with it a 25-year mandatory minimum sentence under the 1020 life statute, which is, again, a creature of the legislature, eliminating judges' discretion in many types of cases. This legislature has allowed what is called mitigators, and they're very carefully construed by our appellate courts as far as what can constitute a mitigator. In this instance, one of the statutory mitigators is whether or not this case is somehow resolved by a uncoerced plea bargain. And that's exactly what we're dealing with here. There is a mitigator that the legislature has allowed to be taken into consideration here. And that is an uncoerced plea bargain. But the plea bargain that is present in front of me was an agreement by the state, representing the people of the state of Florida, to allow a reduction of the crime charged from the second-degree murder with a firearm, carrying with it that mandatory minimum sentence, to a plea of guilty to manslaughter. Manslaughter in and of itself is punishable by up to 15 years in state prison, but because of the use of a firearm has an enhancement, again, by what the legislature has put into place, taking it up to a maximum of 30 years in state prison, increasing the level from a second-degree felony up to a first-degree felony. This is all things that I have taken into consideration. We're dealing with the situation that the state, pursuant to the agreement, has left it to me to enter a disposition, and that disposition is something that I take very much to heart. I mean, I'm not sitting here judging the character of this man, the soul and heart of this man. I am having to judge the circumstances of a crime. I have sat down and scrutinized the videos. I mean, I have gone frame by frame of those videos, I don't know how many times, as far as what occurred on that day. And it's right, it took only a split second, but a gun was raised and a man was shot in the back. as he was exiting a store. The circumstances, you all probably have some concept of what they were, but the bottom line is that a man stealing from a business was shot in the back as he was leaving the business. One of the purposes of any sentence from a jurisprudence point of view is that sentence of courts have to be a deterrent to those out there, and anybody that has a gun is exposed to consequences of the use of that gun, which they have to accept the responsibility for. And that's one of the big things in today's world with the number of guns and guns violence that's occurring out there, that there has to be consequences to people using their guns. Just because you have a concealed weapons permit doesn't permit you to shoot somebody. So we're dealing with all of that I have to take into consideration. You are all here, obviously, because you respect and love this man, and that's obvious to me. It is not lost on me. I've got friends out there that have testified, and I understand and respect all of that. But my role as a judge is to impose the law, to apply the law. The state would have me sentence you, Mr. Dunn, to 17.5 years under the terms of the agreement. The legislature, in looking at the score sheet, would have me sentence you to 124.5 months, which is just over 10 years in Florida State Prison. That, according to, and what I'm looking at is what's called, again, the criminal punishment score sheet, and it sets right on there, the lowest permissible prison sentence, unless there are mitigators. And here the state has entered into an agreement which allows for a statutory mitigator and allows me to pronounce a sentence. And I know I'm not trying to drag this on, but I want you all to understand what this court system is about. And in this instance, I am going to exercise some discretion. I am finding that this plea agreement was pursuant to a legitimate departure from a legitimate uncoerced plea bargain. However, I am not going to impose the 17.5 years. I'm not going to impose the 10 years. But I am going to impose a prison sentence. Mr. Dunn, based on the plea agreement wherein you pled guilty to manslaughter with the use of a firearm, again punished with up to 30 years in state prison, I am at this point finding you guilty and adjudicating you guilty of manslaughter with the use of a firearm. And I'm sentencing you to 3 years in Florida State Prison, followed by 10 years of probation. While you're on probation, I'm going to impose that you do at least 200 hours of community service over that period of time. I'm imposing fine and court costs in the amount of $518. There's any cost of prosecution and or attorneys.
Your Honor, we're not asking for cost of prosecution.
Okay, so it's the fine and court costs that are imposed as a result of that. Those amounts need to be paid within 9 years of the total 10 years you're on probation. You do have 30 days in which to appeal the judgment and sentence. And if you cannot afford a lawyer, one will be appointed. Any questions at all?
Thank you for your time, Your Honor.